Hello, my name is Peter Bricks. I'm a debtor bankruptcy attorney in Atlanta, Georgia. Today we're going to talk about short sales and bankruptcy, how they interplay with each other. But first I want to read this disclaimer. We are a debt relief agency proudly assisting consumers in filing bankruptcy. However, there is no attorney-client relationship with the reviewer of this message unless there is a fee agreement. Your situation is unique to you, and we would need to consult with you individually before we could offer you applicable and accurate legal advice. This information should only be used for educational purposes. Today we're talking about short sales and bankruptcy. So this one we got to first start talking about short sales, as a way to avoid bankruptcy, because sometimes I'll meet with a client who is that's not very uncommon. They're underwater in their house, but this client might say, well, I am underwater in the house. I don't really necessarily care about living in the house long term, but I'm concerned about being pursued for the deficiency. Therefore, maybe if I could complete a short sale, the bank forgives the debt, then I am willing to accept, that's obviously not good for my credit, but that if the terms are such that the debt's forgiven, I'm willing to accept that. So that in that scenario, what the debtor's basically trying to accomplish is avoid bankruptcy. Now they will get 1099'd for the debt forgiveness if it were to occur. Most likely, depending on the type of property, they're going to be able to get out of that tax consequence. Certainly under current laws, as if it was the primary residence. But the thing that's happening here is the debtor's trying to avoid bankruptcy. The bankruptcy itself is going to get rid of the debt. So if the debtor could always have the option of bankruptcy to get rid of the debt, but here the short sale is being used as the mechanism by the debtor to avoid bankruptcy. Now, if the short sale now one thing to consider with these short sales is there might be multiple mortgages. So now you're, of course, going to need the first and second lender to sign off on this and approve this. In this, this varies by state law as far as, well, what if the short sale is not approved? The debtor could even say, well, I really don't want to file bankruptcy. I'll even accept the foreclosure. I just don't want to be sued for the difference. So this is going to vary by state law, whether, it would depend on how many mortgages, a first or a second, what the mortgage was taken out for. Was it a, quote, purchase money mortgage, or was this a refinance? Was this an investment property? So the lender's ability to pursue the debtor for the deficiency are all going to be predicated on those things. So the debtor could even use the foreclosure process almost as a short sale, and say, well, if they can't come after me even with the foreclosure, I'll just go ahead and accept that credit hit, but I'm not going to be pursued for the difference. Now let's take the example where maybe the debtor needs to file needs or wants to, however you want to phrase it, file bankruptcy anyway. They have $100,000 in credit card debt. They're going to file bankruptcy anyway. So the short sale, a short sale before bankruptcy might accomplish some things for the debtor. It will appear as a short sale on the credit. The debtor will get out of, what if there are HOA dues? The debtor is technically liable for HOA dues from the bankruptcy filing date until the ultimate date the debtor's off title. So we'll get him off HOA dues because, for all I know, the debtor's vacated the property. So the debtor's not getting anything advantage of still being in the property. So the debtor in that case wants to complete the short sale even though the debtor's filing bankruptcy. But the more typical example is the debtor has not been approved for the short sale. The debtor gets the foreclosure notice. The debtor just says, well, look, I'm going to need to file anyway to avoid the deficiency. So now I'm in bankruptcy and I'm still in the property because my bankruptcy was filed before the foreclosure. It stopped the foreclosure. Does the debtor need to or want to conduct a short sale now that they're in bankruptcy? Well, the primary reason anyone does a short sale is to get rid of the debt, to settle off the debt. Well, if the debtor is in Chapter 7 bankruptcy, the debtor can discharge the debt by virtue of the bankruptcy. So is the short sale going to do anything extra to the debt that the bankruptcy has already accomplished? That answer is no, at least as to the mortgage. Now, the debtor is liable for HOA dues. The debtor, until the debtor's off title, the debtor is liable for like county fines. Let's say they're not maintaining the yard. The debtor is liable for property, for like a slip and fall on the property while they're on title. So the debtor does maintain some liability, which the short sale, if the debtor accomplishes a short sale after bankruptcy, as soon as the debtor short sales that the debtor's no longer liable because the debtor's off title. Here the debtor is liable. But so if the debtor keeps the property, it is liable. But then you really want to say, well, the HOA dues are only $200 a month, and I can maintain my homeowner's insurance to protect me in the slip and fall. I'm living there. I want to maintain the yard, so the debtor might be advantaged by just saying, I'm not even going to do a short sale. The banks wouldn't work with me. I couldn't accomplish anything. I had to file bankruptcy. So now I'm going to stay in this property until they do the foreclosure. Why should I short sale it in May when they're not going to get around to foreclosing till October? And I can use those 5 months to maybe build up a nest egg for my next place. So those are the factors you want to consider when you're looking at short sale before bankruptcy, short sale during bankruptcy, short sale even if you're on title after your bankruptcy discharge. And that covers short sale and bankruptcy.